Hello, this is Professor Neil Hamilton from the Drake University Agricultural Law Center. I want to welcome you to this installment of our series, Law for Landowners, 10 Things You Should Know. Today, our topic is 10 things you should know about using a conservation easement to permanently protect some feature on your property. Suppose you own a field that includes native prairie, and you're interested in seeing it permanently protected. One idea you can consider is a conservation easement. Here's what you need to know to understand how conservation easements work. The first point is that a conservation easement is a permanent legal agreement in which some part of the property has actually been transferred to someone else. When you think about a conservation easement, what's being transferred is typically the right to make some type of change in the property. The idea being that whatever you're trying to protect, in this situation, the native prairie is going to be the use that's going to be protected. And the conservation easement is going to transfer the ability to make other changes, such as plowing that prairie up, to another organization, the goal of that organization of which is to see that the prairie is protected. As you can see, the real value in the conservation easement isn't granting to another party the right to make some type of affirmative use or change in the property, but instead it's designed to make the conservation permanent. That's why it's called a conservation easement. The second point then to remember about a conservation easement is that it's actually a conveyance of an interest in real property, and they're typically perpetual, meaning that they run forever. The effect of this is that anyone who might acquire that property in the future, such as a buyer from you or your heirs who might inherit it from you, is also going to be bound by the terms of that conservation easement, because the easement is going to be recorded as part of the property title. The third point to think about is, well, what type of organizations or who is interested in taking a conservation easement? Here in Iowa, we have several different types of organizations who are involved in conservation easements. For example, the Iowa Department of Natural Resources, who are responsible for our park system, often is engaged in accepting or acquiring conservation easements from landowners who want to see their land protected and who have land and resources that are of interest and value to this public agency. A second type of organization that is often involved in conservation easements are our county conservation boards. They are responsible for the local park system, and many of them have acquired conservation easements. A third group is the USDA. Through the Natural Resources Conservation Service, several of the USDA programs involve permanent easements that are essentially conservation easements. The Wetland Reserve Program, which operated for decades, covered millions of acres of restored and protected wetlands. That program now is part of the Agricultural Land Easement Program, which also can involve easements for things like farmland protection. And so the USDA is involved in conservation easements. The fourth category of organization that is oftentimes involved in conservation easements are what are known as private land trusts. These are nonprofit organizations that are created for the purpose of working with landowners to conserve land. Here in Iowa, we have a number of land trusts. For example, the Iowa Natural Heritage Foundation is involved in many conservation easements. I've had the opportunity to serve on the board of the INHF, and so I'm familiar with their work on this area. In addition, there are other land trusts in Iowa, such as the Burr Oak Land Trust and the Nature Conservancy, that are involved with conservation easements. An important issue to keep in mind is if you're going to work with a land trust, be sure and determine whether or not they've been accredited by the Land Trust Alliance, which means that their practices meet certain standards in terms of the legality and the permanence of what they're doing. The fourth point to keep in mind is to think about how a conservation easement is enforced. Well, once a conservation easement has been recorded, you can expect that the organization that actually received it or obtained the easement has an interest in making sure that the underlying conservation value, for example, this prairie that you're protecting, actually happens. One of the ways the organization is going to make sure that in fact the terms of the easement are carried out is that they'll probably do some type of annual inspection in which they'll physically come onto the property to make sure that there haven't been any infringements or changes being made. If they are found that there's been some type of action that looks like it may be a violation, then that will begin a communication between the parties to the easement to see if the violation can be corrected. If it can't be corrected voluntarily, then there's the opportunity for some type of further legal action to actually enforce the terms of the easement. The fifth point to think about is the question of, well, why would you consider creating a conservation easement? Well, as we've talked about, there's some type of underlying conservation goal. Farmland protection, protecting a prairie, perhaps protecting an oak savanna. There's something that you as the landowner are interested in seeing protected permanently. The idea of creating a conservation easement is that by transferring that goal of protection to a third party, you can be sure that that protection and that conservation value is going to continue after you're no longer the owner, perhaps even after you're no longer here. So the idea is, how is it that you can actually permanently achieve this protection and have the peace of mind knowing that those conservation values are going to continue? So you should recognize that creating a conservation easement may not really have any effect on you today because it won't change what you are currently doing. For example, you were enjoying having the native prairie. The key with a conservation easement is the idea of what might happen in the future. The sixth point to consider deals with what might be the financial or economic benefits of a conservation easement. Well, there may be some economic benefits, particularly if you might be able to qualify for some type of tax deduction for the actual transfer of the conservation easement. Under federal law, qualified donations of conservation easements can be subject to a tax deduction, and many states have similar laws that provide deductions for state taxes for the value of the property interest that is essentially being retired because of the conservation easement. So while finances may be an issue, I think in many situations the real motivation of people who donate conservation easements is that they have the peace of mind that the conservation goal is going to continue into the future. Now, a related question may be, well, will I get paid for the conservation easement? In most situations, this is unlikely. And in fact, if you're making a contribution and expecting some type of deduction for a charitable contribution, you won't be paid. But depending on the nature of the interest that's involved, payment may in fact be required or even expected. The most common example of a paid conservation easement, for example, would be a farmland protection easement, in which some significant value, such as the right to convert the farmland to houses, is actually being retired. In that situation, it may only be possible for the landowner to justify making that transfer and imposing that restriction on the use of the property if there was compensation. So, the issue of whether or not you're going to be paid depends on the nature of the restriction, perhaps how restrictive it is in terms of the amount of property value that's being retired, and whether or not the party who's on the other end of the easement has the resources or has funding available to actually acquire them through purchase. The seventh point to think about with a conservation easement is the issue of, will the public be able to actually use the property and come onto it? The typical answer to that question is no. It depends, of course, on what the language of the easement is. But in many situations, all the easement does is actually preserve the conservation value. It doesn't make the property subject to public use or enjoyment. It's not the same thing as selling it to the county or the state to turn it into a park. Instead, the property remains in your private ownership, subject to the terms and conditions of the easement. Now, there may be easements that provide for some type of public use. For example, perhaps there's a trail that runs across the property. Or let's say there's a trout stream that the state's interested in acquiring an easement for people to be able to fish in. In that situation, the easement could provide language for public use. And it's important to look at the language so that it sets some type of guidelines or restrictions about kind of either when or where or the extent of that public use. This is one of those important questions to think about when you're looking at and drafting and reading a potential conservation easement for your property. The eighth point to consider is to think about what are the most important provisions to consider that are going to be in a conservation easement. Now, the language of any conservation easement is going to vary depending on the nature of the property and the organizations involved and the interest of the landowner. But there are a number of important common points that you need to think about. Certainly the description of the property, the nature of the easement itself. What are the restrictions that are being imposed? What's the nature of the conservation goal or value that's being transferred? The identity of the parties, for example. Who's the organization or the agency, for example, that's acquiring the easement? What's the length of the easement? Most of them are in perpetuity, or meaning they'll be perpetual, but some states may provide for easements to be of a shorter term period. Of course, if there are any economic considerations, if there's the expectation of a donation or a deduction, that might be an issue to think about. The question of public use, the question of responsibility for fencing, for example, if there are neighboring properties. These are the type of questions that, in working with your lawyer, because you do need a lawyer to work on these issues. This is an important legal question. It involves an actual transfer of property. But those are the type of questions that your lawyer will help make sure that you ask and get answered. The ninth point to think about with a conservation easement is, how will its existence be communicated? Well, of course, if you were involved in signing it, you know about it. And in most situations, your other family members are going to be aware of it because you probably involve them in a discussion and a communication about your goal of creating the easement. The easement's going to be recorded in the land records, which means anyone who was a prospective purchaser, for example, would find out about it because it would show up in a title search that would be being done on the property. But otherwise, you may not know whether or not there's a conservation easement in existence on property. Some organizations may put up signs that say, this property is being protected under a conservation easement, but that isn't necessarily the case. And in fact, it may not even be that important for anyone else to know whether or not the land has been protected by a conservation easement. The key is, or the people who acquire the property from you will know, because you have a responsibility to see that the easement is implemented, and the organizations that are on the other end of the easement that are actually holding it, they know as well. A 10th point to think about is, well, what might happen if in the future, if someone objects to the existence of the easement, or if the circumstances change such that it no longer should be carried out? Well, as you recognize, the goal of the conservation easement is to, in fact, make sure that these conservation values are carried forward to the future. We can expect that future circumstances may change. People may want to go back and to plow up a farm that was protected permanently under a farmland protection program. But that's the idea of the easement. Unless there's been some circumstance that's so radical that the existence of the easement can be challenged, or if for example, the heirs of your heirs, because you created the conservation easement, can somehow prove that there was something undue about the process or illegal about its creation, there are only very rare circumstances where a conservation easement could be changed or challenged. Instead, part of the value of the conservation easement is how people know about it, how it's communicated to future interest holders and others who may come into contact with it. So that's an important reason to think about what you may be doing if you're granting a conservation easement, recognizing that you should expect that these are going to be in place forever. That's part of the goal of the conservation. Now, I told you that there were only 10 points, but with many things there may be other issues to consider as well. And so here's our bonus point about conservation easements. Let's call it number 11. And that is that both of the parties, if they're married, a husband and a wife, both have to sign the conservation easement for it to be effective. Because as with most grants of real property, husbands and wives or spouses have an interest in the other party's property. And so if you don't have signatures by both parties that recognize that they were in fact aware of what they were doing and granting away their interest, that may be one of the ways that a conservation easement could be challenged. Thank you for your interest in conservation easements. This has been Professor Neil Hamilton with today's installment of Law for Landowners, 10 Things You Should Know About Conservation Easements.